And so
for the ruling on that.
He's here, said, he said, where do we start? He said, I don't even know what to do.
Automatically.
Good evening, and welcome to our special workshop in Crestwood City Council. At this time I ask if you have any electronic devices that you turn them off. If you care to speak, anybody in the audience, you need to sign up before you come in front of the council. I welcome Crestview News Bulletin back in the room. CCTV is covering some kind of a game tonight, so we're backseat to them. Anyway, at this point, at this time, I'd ask that Councilman Faircloth would lead us in the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay, we don't sign in the workshop because we don't vote, but be it noted that we have two councilmen absent. Councilman Joe Blocker, who is in a hospital appointment in Pensacola with his wife, and Councilman Shannon Hayes. We're not quite sure where he is. He might pop in at any moment. We don't know. He might be caught up in that darn traffic on State Road 85. You never know. But that means we do have a quorum because we have three councilmen here. We also have the mayor here, the city clerk, our city attorney, and three of our department heads, or acting as department heads. Looking at tonight's agenda, which we only have one topic, does anybody have any issues with tonight's agenda? All right, then we're going to move on with what's on the agenda. This time, anybody in the audience would like to speak to us on anything that's on the agenda? Anybody in the audience? Okay. Seeing none, we're going to move right into workshop item 6A, itinerant vendors, and be presented by Ms. Gaylord from our staff.
Okay. Gentlemen, this is not a new conversation we're going to hold. It's I guess first started back in 1994 when they passed the home solicitation ordinance that was promptly cut out of the code 2 years later. So we are going to run through our ordinance. You'll see a lot of it. It deals with mobile vending and how state of Florida regulates mobile vending, legal issues that can come out with it, and concerns for mobile and itinerant vendors concerning public health and safety, community impact, economic impact, and there's many arguments against regulating, which means that you restrict free markets and you prevent from starting up businesses. Okay, a lot of things have been done to that we've used to help guide the process. We've used license fees, application fees, background checks. We've used temporary stands. We just really need to come to a conclusion and put down some hard and fast rules of what can be done and not done in order to guide our vendors and the best way we can. Our ordinance, our draft ordinance here, we haven't got it numbered because we're going to wait until we get a little more towards the finish line.
And what I'd like to do, Teresa, and you don't even really have to read the ordinance because that's going to be what we're going to accept at the end, just like we talked about.
Yeah, I'm just going to hit what the
Walk us
provisions.
through the ordinance.
That's
through
all
each
I'm going to do.
section, and then each section will render any questions or comments.
Yes,
okay?
sir. That's the entire plan.
All right, good enough. Thank you.
Okay. And our the article that will be created will be 24. I always get the L, the I, and the V translated. So it's article.
You got your Roman
24.
numerals down. That's
Okay. And we pretty much understand the purpose and intent. So if there's any clarification y'all need there. your definitions, our definitions come directly from our state statutes, the Florida Administrative Code, DBPR. These are already definitions that exist at a higher level than the city. So unless in perusing through them that we somehow think we can give a better definition, I would suggest that we align ourselves with how the state and county agencies define the certain items. I haven't found anything that would need a definition that does not have an adequate one in the Webster's dictionary or in one of these definitions that come from the state. So in saying that, unless directed, we will not peruse the different definitions.
Anybody comments, questions on the definitions? Yeah, go ahead, Councilman Fairclough.
I gave this a cursory review with the time I had. And I found that 99% of this entire ordinance is aimed at food vendors. I saw very little, if anything, about car sales. And so I'm wondering if car sales would fall under peddler.
You're talking about the car sales that are from agencies that come in and put out?
They
They would
bring
be,
200 cars in here, put up a big tent.
they fall under the solicitation definition as well as the peddler. They do not have a defined specific category for the vendor itself. They are simply itinerant vendors, which mean that they're all people, firms, corporations, they're agents, anybody creating temporary or transient type business. So they would fall into that. You no longer specify them as simply food vendors, car dealers, insurance salesmen. They have a broader category at the state level. They're all itinerant vendors. They're transient vendors.
Mr. President,
Yeah, go ahead.
just to kind of prepare my mind for this discussion, could we have a short discussion?
Oh, yeah, we can, but before we do that, I would just ask you to look at itinerant vendor. Don't you think that would cover anybody that's going to sell anything in the
Well,
city?
yeah, I thought that and I made a note
Okay.
of it.
All right, let's go
Okay.
ahead and discuss it.
Okay, I have said before that I've received numerous complaints from car dealership owners around here. And when I really sat down and tried to weigh the itinerant vendors ordinance, compare it or include the car dealers, whatever, it all boils down to if you got something to sell and you want to do it out of a tent or a trailer for a few days or whatever, then it doesn't matter if it's food or I guess hot dogs are food, hot dogs or ice cream or slushies or a car. Now, although our dealership owners are not real happy with these people that bring 250, 300 cars up here from South Florida, put them under a big tent, and then take all those sales away from our local dealers, is really not any different than somebody selling hot dogs taking sales away from the restaurants in town. But it just seems to me that even though it seems to be the same, that ought to be a different category. There's just too much money involved, and we're not protecting our local dealers, when I think we ought to give them a little more attention.
So you're directing, let's go through the ordinance and then we'll have the discussion, because we cannot directly single out one particular set of people. We must consider the actions that will be taken, broad spectrum, over what the state declares as itinerant vendors. Now, let's go through the ordinance, and then we'll pose your question at that time. Is that fair?
Okay.
Okay.
Okay, go ahead.
Okay, so
Other than that, we're good with the definitions, you think? Move on from definitions, okay. You're good with that, right? Okay.
okay. Okay.
So are we page 7?
We're on the bottom of page 5 of
Oh.
your ordinance.
Oh, we're dreaming.
It's only like 2 sentences there.
Okay, I see.
Okay, it's the itinerant vendor peddler solicitation compliance certification, which shall be required. It will be unlawful for any person, firm, cooperation to engage in a business activities of itinerant or mobile vending, peddling, solicitation within the city of Crestview without first registering with the city to obtain an itinerant vendor, peddler, or solicitor's compliance certificate. The itinerant vendor, peddler, or solicitor wishing to engage in business activities, let's just say concerning this particular trade, within the city of Crestview shall make application to the Growth Management Department on forms provided by the department. The Growth Management Department for the city of Crestview shall issue an itinerant vendor, peddler, solicitor compliance certificate authorizing such vendor, peddler, solicitor to sell, exhibit for sale, or offer for sale in the city of Crestview any goods, wares, or merchandise only after such itinerant vendor, I wish there's a way to, can we just say vendor, and y'all will know that I'm,
Yeah, yep, that's fine. We know-
that's
we
good,
know what you
that'll
mean.
speed it up, you'll know. Shall comply with all the provisions of this article. They shall be valid for 1 year, as described in item B. They will have an annual registration fee, and it will fall into the categories of itinerant, auto-oriented sales and events. This category shall include the itinerant sales of self-propelled vehicles and non-self-propelled vehicle trailers, to include not limited to cars, trucks, fifth-wheel trailers, trailers, campers, off-road vehicles, motorcycles, dirt bikes, boats. I don't really know what a ski-doo is, or jet ski, and others. This category shall include temporary auto consignment lots. The category does not include a one-time sale by a single vehicle by a resident of the city. There is tent sales, which is another category. It shall include the seasonal and non-seasonal items. It can include semi-mobile or stationary temporary sales and events that will not be, they're similar to your Christmas tree lots, your fireworks stands, your home mercantile products, used merchandise, garage sales, that type element is what your tent sales are going to be limited to. And they cannot, they operate on commercial interests. The owner and operator of the commercial enterprise shall have the express permission of the owner of the property that they're displaying on, and cannot be within 15 feet of your primary structure on the lot. Mobile vending, truck and trailer. This refers to those that are in a self-propelled vehicle or otherwise pulled or moved by a self-propelled vehicle. The category is what the state calls an MFDV, and that includes those that either have water and sewer connections or a commissary at another location, and also included is ice cream trucks. And your mobile food cart, that is synonymous with your push cart, hand-drawn cart, and your hot dog cart, which are a class of the MFDV. And they will be exclusively for retail sales of things like plants, flowers, fruits, vegetables, beverages, prepackaged foods, hot dogs, sausages, and ice cream. So that's more or less like your hot dog variety of vendor. Each applicant for a compliance certificate, will make applications, submit to a background investigation. Upon receipt of such application, a copy will be transferred to the chief of police, who shall make the following type of investigations. Commercial activities, where the chief of police or designate shall cause an investigation of the applicant's business and moral character to be made as he deems necessary for the protection of public health, safety, and welfare. The applicant shall include any and all employment information deemed necessary by the chief of police. In addition, a copy of all vendor's application must be submitted to the chief of police for approval. The next portion of your certificate, your compliance certificate under this article will be filed with the Growth Management Department, a signed application which shall involve the following information: the name of the applicant and each person who owns 10% or more of the outstanding stock and equity interest in the licensed activity, and a valid driver's license. A permanent home address, valid telephone number for the applicant, address and parcel information, and the planned vending site, including the property owner's name and telephone number. A brief description of the nature of the business or goods, foods, beverages to be sold. The address of the commissary, if applicable. The applicant's vehicle, make, model, color, and tag number, if applicable. Email address. The applicant shall provide their federal employer ID number and sales tax identification number. A notarized statement from the property owner that the temporary use is allowed on the property, and the statement must include the temporary use dates, including setup and takedown, location, description, type of business, and representative designated by the property owner.
Okay, gentlemen. Comments, questions on that one section? Go ahead, Ms. Cox.
I just want to congratulate Teresa and Growth Management and everybody that worked on this document. This just wasn't thrown together. This is extensive, all-encompassing. It's an excellent, thorough working document, well explained.
Thank you, sir.
Thank you for those remarks.
Thank you.
You have anything, Ms. Fairclough? Ms. Mayor, you have something for us?
Teresa, what is the process for those who sell at the farmer's market? Do they have license or permits to do that, or is that just open to any folks who want to come in and sell vegetables?
Is that where you sell vegetables at the park? Did
At the
you
Spanish
have
Trail
that
Park.
under your application?
No, I was just wondering about the people who do sell there. Is there any kind of regulations for them to, any permitting that has to be done at this time?
Not at this time.
Okay. That's what I
We
wanted
did
to
not reach out and include them as they're in a specific venue that the city has designated. You can come here and sell your vegetables.
know. Right, that's what I was hoping.
So
It
that's
stays
all
that
we
way.
have there.
Needs to stay that way.
Because these are people that are trying to be on somebody else's property, and our venue at the park has road, it has parking, it has a safe way to enter the venue and a safe way to exit it. And you're sitting right next to the police department in case you need them. So this is people that want to set up on various places who may or may not have the proper access to the proper parking, and it may be, you can't be in a residential area, although some try to be there. So,
Mr. Steele.
Yeah, go ahead, Ms. Cox. You're done, right, Ms. Mayor?
Yes, sir.
Okay, thank you. Go ahead.
Mr. Steele.
Yeah, Mr. Steele, you have something for us?
Mr. President, I've got a question. I kind of was thinking about what Mr. Fairclough said about the automobile sales. Those are major purchases. It seems like to me we would have some type of protection for our citizens in the event someone went out and purchased something like that and they're not local. That's a major purchase, and it needs more discretion. Couldn't we write in some type of ceiling for the amount in this vendor and say anything above this amount falls under this category, anything less than this is a regular itinerary vendor? But because those are major purchases, and And if you have someone that's, that goes there thinking this is it's a place of reputable business, and they buy a car and then it fails after these people are gone, do they have to go to South Florida to seek repairs? I mean, or to get their, you see what I'm saying? That's just a question. And the thing about the farmer's market, we're under the grant that we received to build that dictates we have to let local farmers come and sell there. That's two separate things, but that's just a question I was thinking about.
I'll address that in a minute after everybody else is done. Go ahead.
Okay.
Yeah, go ahead, Mr. Cox.
Yes, on automotive sales, major purchases, yes, but it's still caveat emptor.
Should we continue on?
No,
Maybe
I
it will,
have
it will
several-
answer
I have
a lot
several-
of questions.
No, I have several questions.
Okay.
First of all, and it kind of bounces off what the mayor was saying, and that is, I think we try to control it a little bit now, but do we actually have anything called a compliance certificate at this point?
That's what we're creating.
I know, so
This is
we
it.
have nothing at this point, is what you're telling me? Nothing to even look like this?
That looks like this? No, sir.
Okay.
Nothing at all that looks like
All right.
this. Now, businesses have to get a BTR if they're like a registered
Collecting
building, but
tax
not I don't think there is any temporary vending license, is
Not
there?
for temporary. If they're a mobile, like the Ruck Up Cup or the guys that are over here by Nathan's, they have to get a permanent BTR.
So we do have something.
For-
That's a
Nothing.
permanent
But
BTR.
if people that are
All
not,
right.
or like semi-permanent, they
Okay,
leave, yeah. If they're doing business in the city, they have to have a BTR for, being here for any length of time.
the second question I have is the requirement, that someone have a driver's license. Well, we have some people that have disabilities that may not be able to drive, but they can operate a business. It sounds discriminatory if we tell them that they have to have a driver's license.
If they have a driver's license for ID, it's for, let's see where we're at.
It
It's
says
for
they must
identi-
have a valid driver's license.
let's see where we're at.
You can make that valid driver's license.
Page
stamped ID
7D1.
card.
Yeah.
You could just make it a
Registered.
Florida issued ID.
They-
Yeah,
that would-
Florida
that would be
issued
good.
ID. What we're looking for
Tomorrow.
is an ID. What happens now is like with the car dealers that has come in, nobody can identify
No,
who they are.
I
and
agree with
stuff.
that. We just need to
So-
reword it to say, or a valid Florida ID.
Would it have to be, I'm sorry, would it have to be a Florida ID? What if it
No.
comes from somewhere?
No.
A valid ID.
Yeah.
Okay, I'll buy into that. Next one, would you define commissary for me? Because that means different things to different people. Is that supposed to be the supplier? Because to me, if you tell me commissary, I'm gonna go with Eglin and shop and get some food. But you
Okay.
tell it to a
No.
regular, what does commissary mean to you, Mr. Cox? Do you know what it means?
Your commissary is actually defined in your state. Let's see if it actually,
Almost.
Main in here.
If it's a supplier,
no, sir, it is actually where, it's actually in when they're getting their license through the DBPR and the administrative code, they mandate a commissary. That is a place where they go back and have their water and their wastewater. It's like where they take care of it. They take their mobile vendor back. It's not about supply. It's not supply and demand. It's either you supply your own water, you hook up to utility connections, or you must be under a commissary where you take your vehicle back, all the gray water's taken out, it is cleaned, your fresh water's in there. They have certain inspections and tests at
Well,
the state
then-
level for those.
then I would say that, since I don't see that definition, I would say we need to explain what it is.
Okay,
If you
we
tell
can add
someone
that
we need to
too.
address you to commissary, and they say, my what?
Well, anybody's got a mobile truck will well know their commissary,
Well,
but
they're
we will
selling-
include it in our
They're
definition
selling
so
auto
everybody will
sales-
know.
they're Selling auto sales, they may not. Okay, and the other thing, and they both relate to the auto sales. One is, we need to really coordinate with the chief of police whether they can do, in a timely fashion, background checks, because I have to do background checks on the people that I oversee, for seniors versus crime, and there was a recent change in the last year where the local police couldn't do it for me anymore. It had to be, I forgot where it's being done now, but chief couldn't do it locally. It was taking longer. It was taking a month or so compared to normally 3 to 5 days. And that one check-
I think we're looking at allowing for being applied for 21 days in advance. So if this, like I say, this is our first draft, this is kind of what we're supposed to be, is finding what we can do and can't do, but this is what is done in other,
Yeah, I'm just saying that we
municipalities.
need to check
We
with the chief
will.
of police and make sure they can be done. Now,
Right.
getting back to the auto sales, and it's a good point, you know, what Councilman Cox said, because for those of you who don't know, I oversee a special project for the Attorney General's office, and we get complaints. And the biggest complaints we get are people coming in selling vehicles and going away, and we had no way of tracking them, this is gonna be done. But on the other side, even if you do track them down, if you buy a used vehicle as is, there's no lemon law for used vehicles. So
Exactly.
you can track them down all you want. You're not gonna be able to recover anything from them unless you can prove the individual committed fraud. You know, actually cheated them somehow, but if they sold them a bad vehicle. I don't really think you can say that if you're selling something of this value, you can do it here, but if it's up at this value, you can't do it there. I think you're going to get involved in discrimination again from certain sectors.
My question wasn't to say not to allow it, it just fall under a little different category with different restrictions.
But they have to have background checks and a place
Right.
we can track them down.
That's what I meant. It was be,
Well, we're going to do that for everybody.
right.
Even if
it
you
was
sell
have
peanuts.
something more than just having a, you know, I know yard sales are exempt, but you understand what I'm saying. You go into a place and buying a barbecue sandwich, it's a lot different than at a food vendor than it is going and buying a car from a,
Oh, I know, I hear it.
right.
Councilman Cox, you have something? I'll
Yeah,
get you in
car's a major purchase. What I wanted to note was, back on the background check thing, note that in the documentation provided, Fort Walton Beach and Destin do not require that.
Don't require any background check at all?
they don't require the
According to
back.
this chart on page 6.
Yeah, that is just our very local ones here that I shown. When you go broad spectrum across the whole panhandle and the upper portion of Florida, you will find that a lot more do. Then, and there again, some of our local people have enacted ordinances that control the situation in a different way, so that they are no longer inundated with the need for that.
But you know, one thing we need to look at, in a background check, who's gonna make that determination that what's in your background is gonna preclude you from operating in Crestview? For instance, the last time we discussed this, I had a business owner come to me and say, JB, I smoke pot. I got busted with pot 20 years ago. Does that mean I can't have a vendor in Crestview? I don't think we're looking for that. Who's gonna determine what criteria we're gonna use to say you can have a business, you can't have a business?
Well, that will progress into phase 2 when we go to having our criteria and our application forms and our fees that we're going to have to set and different items that will follow the policy that we're going to enact. So this is not the whole meal deal. There'll be items down as we tweak out what we want and what we don't want. Then we will tweak out to say, okay, this maybe application fees. Maybe this application fee needs to be $10. An application fee like this needs to be $10,000. So it needs to. That's part of what you will tweak out when you find what you want to keep of this ordinance and what you do not want to keep. So.
Are we ready to move on?
Mr. Mass?
Yeah, oh, I'm sorry, Madam Clerk.
That's okay. I'm pretty sure I saw it in here somewhere when I was looking through this morning, but festival vendors, they're not included in any of this, like a one-day festival, downtown festival. They don't have to go through this 21 days in advance for a mobile food vendor for a festival somewhere.
They're actually, the state declares them as being, and there's a write-up in the book that covers the mobile food services. They also cover your temporary events. They have now reclassified temporary event vendors into a whole different category at your Florida Administrative Code. And it dictates on where the survey, the service that they will be providing, what time, how many days.
But I know right now
Is
we
that-
have it in there where they don't have to have the BTRs for a temporary, for downtown festivals and that. I just wanted to make sure we're not
I
putting some
think
in
it
there.
does. I'm pretty sure it does. It's a 1 to 3 days.
It's a,
1
it's,
to 3 days permit's required.
Yeah.
you have a 1 to 3 day permit, but it doesn't go to the extent of somebody that's going to be setting up business for 15 to 20 or 30 days
Because, I
or
mean, they're
whatever.
already paying a fee, like to Main Street. I don't want them to have to pay a fee to us and pay, we're not gonna get any vendors if they have to start paying fees to everybody to get downtown for the Main Street festivals.
Yeah, the temporary events should be last 1 to 3 days, which includes food, contests, cook-offs, which will be hosted by a church or religious, a nonprofit fraternity, a nonprofit civic organization are exempt. Upon request of the division, the event host must provide the division documentation of its status as one of those organizations. So it's 1 to 3, 1 to 3 days.
Main Street's a not-for-profit, so it would
Yeah,
fall
so.
under that, okay.
But it's a 1 to 3 days, even if you are a not-profit.
Never,
Okay.
I mean, their events are never more than 1 day, so.
So, anyway, they're exempt. Are we ready to go,
We are
continue
ready.
on with the temporary vending permit?
102-602.
Yep. It shall be unlawful for any person, firm, corporation to engage in business activities of an itinerant or mobile vending, peddler, solicitation with the city of Crestview without first obtaining a temporary vending permit. The temporary vending permit is issued on such conditions as the Growth Management Department may reasonably require, assuring compliance with the cities of Crestview's Code of Ordinances. All applications shall be received for a particular location, will be processed on a first-come, first-served basis. Any subsequent applications received may be issued once the prior applicant has vacated the premises. The compliance certificate shall have been obtained prior to the issuance of the temporary vending permit. All vendors must adhere to all applicable state and local laws. Applications for the permit under this article must file with the Growth Management Department with signed applications. The application shall provide sufficient information to determine if the proposed site and the temporary activity comply with the article, the provisions of the Code of Ordinances. In addition to the application, the applicants must submit copies of all applicable state license, insurance, proof of general liability insurance, such as proof in a form acceptable to the city, ensuring by the insurance company that a license to do business in the state of Florida, protecting the applicant from all claims for damages in properties and bodily injury, which may arise out of the operation under or in connection with the vendor's activity. For all motorized mobile vending units, proof of automobile liability insurance, and proof in a form acceptable to the city, issued by an insurance company that was licensed to do business in the state of Florida, protecting the applicant from all claims of damage to the property or bodily injury which may arise from the use of the motor vehicle in connection with the mobile vending, shall be in the amount of not less than $500,000 per occurrence. If we'll halt here, the option is also included for $1 million. As we go on to item number 3, a site plan, accurate drawing or pictorial representation of the property to be used, rented, or leased for the temporary vending use must include the following: all existing and proposed structures on site, structural dimensions and locations in relative to property lines, the zoning district setback lines, location of temporary sanitary facilities, such as the portalettes and the waste disposal, parking areas, signage, and a means of ingress-egress for vehicular and pedestrian traffic, any additional information necessary to accurately portray the property and to identify the area to be utilized for the event, a description of the property use, and mobile food carts are exempt from this requirement. Door-to-door solicitors and peddlers. if employed, for the name and address of the employer, together with the credentials establishing the exact relationship, a valid driver's license, and insurance, and that should have said insurance in there, and length of time for which the solicitation or peddling shall occur. Item E, itinerant vending permit timeframes. All applicable licensures and certificates and permits must be obtained prior to the installation of any temporary structures, lighting, or signage. Number 2, the application for the permit for all uses shall be filed no less than 21 days prior to the date of which the permit is to take effect. Number 3, duration of your TVP by the itinerant vendor category. Item number A, it would be the itinerant auto-oriented sales and events. A TVP issued to an itinerant automobile oriented sale event use shall be valid for a maximum of 15 consecutive days, 2 times during a calendar year. Each 15-day period shall be separated by at least 30 days within the same calendar years. Date of operation will include the dates to assemble and dismantle the equipment and/or structures. B, the tent sales. The TVP will be issued to the tents for tent sale use, shall be valid for a period of not to exceed 15 consecutive days, 3 times a calendar year. Date of operation shall include dates to assemble and dismantle equipment and structures. Item C, the mobile vending truck or trailer. The TVP issued to the vendor for use shall be valid for a period of not to exceed 1 year, 365 days from the date of issues. D, your mobile food cart. Your TVP issued for the mobile food cart use shall be valid for a period not to exceed 1 year, 365 days from the date of issuance. And the lastly is your solicitors. A TVP issued for a solicitor shall be valid for a period of time not to exceed 1 year, 365 days from date of issuance. Is there any questions?
Go ahead, Mr. Cox.
Yes, sir. Concern question, and particularly as relates to big ticket items, auto sales, or other things. And city attorney, check with me. Hold harmless clause for the city so that when the city issues permits, okay, Mr. Business, temporary business, you're cleared to have your event, but so that the city can't be sued as a third party for commercial activities.
That would be good to explore where to insert that in at as a regulation. Okay, thank you.
Very good. Any
Mr.
other
Whitten,
comments?
Mr. Whitten,
Question, go ahead, Madam Clerk.
I would make a recommendation that we go with $1 million. Our minimum on any kind of vendor activity for any event is $1 million.
That's the reason I say, even though it's common, the $500,000 is common, that's the reason I paused to say, $1 million is not out of the question because it is required by other things. I think even at Warriors Hall, that was the
Yes,
insurance,
if
that's $1 million
Almost
on
everything
it.
we do in the city, we have that $1 million.
At least $1 million,
Okay.
and in some events it's $2 million, so.
Inflation. You agree with that? Go ahead and change that, bump it up to $2 million.
Going once, going twice.
And the hold harmless is something is also required as a lease, so that should be. I think-
And that's usually required, isn't it, with when they get their, anytime they get their BTRs and things like that, or any type of parade things that
Yeah.
they do,
Any-
and
any
all.
event
Any
insurance.
events, the hold harmless is
Right.
usually a standard.
It's a requirement.
Okay, are we ready for 103?
We are ready for 103.
Okay, regulations, restrictions, and site restrictions, use restrictions. Temporary vending operations and events shall only occur within the C1, C2, M1, and DMU zoning districts. Number 2, at no time shall any temporary vending operations disrupt the flow of vehicular or pedestrian traffic or on or off site. Number 3, itinerant auto-oriented sales shall not be located on vacant or unimproved lands. Item 4, itinerant auto-oriented sales and events and tent sales shall be limited to one temporary vending permit per parcel at any given time. Number 5, itinerant auto-oriented sales, events, and tent activities located on any parcel of land or lot of record with the existing primary use building or structure shall be limited to one temporary vending permit at any given time. Number 6, mobile vending trucks and trailers shall not be located on vacant or unimproved lands. There shall be not more than 3 mobile vending trucks or trailers on one parcel of land at any given time. Number 8, mobile food carts shall not be required to maintain applicable zoning district yard regulations, but at no time shall mobile food carts become stationary within any public right-of-way, obstruction of any visual triangle, or obstruct or distract from any vehicular or pedestrian traffic flow. Site requirements. At no time shall a mobile vending truck or trailer be closer than 10 feet to another vending truck or trailer on the same parcel of land. The itinerant vendor operation shall maintain applicable zoning district setback standards for the zoning district for which they're located. Number 3, at no time shall any component of the itinerant vendor operation be located within 10 feet of a permanent structure on site. Parking. At no time shall any temporary vending operations restrict the number of parking lots to a level below what is required by the Land Development Code for the permanent primary use on site. Number 2, adequate parking areas consisting of current zoning regulations for similar uses shall be maintained during the temporary vending use. Parking spaces required to fulfill the minimum requirements for the principal use on site or adjacent to the itinerant vending shall be as per section 102, 151 of this code may not be used by any itinerant vendor operation. B, parking shall be only be allowed on designated parking areas identified by approved site plan. Number 3, no parking will be allowed on any public right-of-way. D, traffic. Traffic generation shall not adversely impact the flow of traffic on any adjacent roadway. Number 2, the use of any existing access drives on or connection to the property, parcel, or lot which the itinerant vendor is located is required. The temporary structures. Only one temporary structure is allowed per permitted itinerant vendor operation. Itinerant auto-oriented sales and events and tent sales shall be limited by the following. Number 1, the temporary structure may be a tent or trailer that has been built to an office trailer. And the caveat for that, temporary structures do not include motorhomes, camp trailers, or the like. Number 2, the temporary structure may require a building permit to be obtained and subsequently require an inspection by the building and the fire departments prior to operation. Number F, sanitation. Number 1, the site will be kept clean of all debris, trash, waste, and unsightly conditions. Number 2, temporary sanitary facilities or portalets shall be kept in a clean and working order. Item G, signage. Any temporary signage shall be installed and maintained in compliance with Chapter 102 Land Use Regulations. Article 16, signs. Utilities. New temporary electrical poles shall not be provided. If one exists on site, it may be utilized for the temporary vending operation, providing it meets the following requirements. Any use of power from the main structure on site shall be in accordance with the Florida Building and Life Safety Codes, and the use of electrical cords are prohibited. Additional mobile food cart requirements. Location. Mobile food carts shall be permitted to operate in commercial or downtown mixed-use zoning districts in the downtown area, bound by Bowers Avenue west to the south, Ferdinand Boulevard to the east, James Lee Boulevard to the west, James Lee Boulevard West to the north, and by Wilson Street to the west. The mobile food cart shall only be located on properties where there are existing use is a non-residential in nature. And that caveat is in there because we have a lot of commercial areas that are within our residential neighborhoods. That's part of the zoning and future land use we need to pull into compliance. Number C, mobile food carts shall not be placed on unimproved surface during the course of business. D, mobile food carts shall sell food and or beverages, shall not stop and conduct business within 100 feet of an indoor and or outdoor eating establishment, including another food cart. E, no more than 2 mobile food carts can be located on any block face at any given time except during organized or permitted events. Number F, at no time shall placement of the mobile food cart impede pedestrian or vehicular traffic. G, at no time shall the placement of the food cart deteriorate any pedestrian or vehicular sight traffic. Triangle. And y'all are familiar with what that is, correct? At the intersection, you have a triangle to either side that must remain clear for the person at the intersection to be able to see how to get through. At no time shall mobile food cart placement be in front of buildings, entrance, fire hydrant, or emergency exit. Number I, all applicable permits must be obtained prior to the installation of any temporary structure, lighting, or signage. Is there questions?
Go ahead, Mr. Fairclough.
Back on, page 9, number 3, itinerant auto-oriented sales shall not be located on vacant or unimproved land.
That's right. Vacant and unimproved land
So
is
my
not
question
way,
is, where the last one was,
is
down
on
there-
vacant and unimproved land.
Yeah, so that won't be allowed anymore?
No, that particular piece had a history and a precedent set for having that type vendor because it's traditionally held with the Christmas tent vendor. For most places, your vending is not allowed on vacant land now. So this will give us something in the code that we can actually stand on.
Now, I'm talking about the, I don't know what, 15 acres maybe, or 20, just south of Marcus Mays and Mitchell Law Firm. Is it Marcus Mays and Mitchell?
Michael's and Booth.
Michaels and Booth,
Okay.
close.
Okay. A vacant or unimproved land means that the access to and from the property has not been accounted for. There's no water, no sewer. There's not a primary structure constructed on the property, hence the vacant. And usually when a structure is built onto a property, they usually account only enough parking to accommodate the structure they're building. Most people do not build a parking lot twice the size thinking that they're not going to use half the parking lot. So unless there are lands that have a primary business built on them with an adequate enough parking lot that it can share with somebody else, this, I don't see any way that it is permissible, because you must prepare the land for what you put on it. It causes erosion, it causes traffic pile-ups. If you're putting a functioning business on a vacant piece of property, which is essentially what was happening. A functioning business was there for several weeks on a piece of property that was not established. They had no control over their stormwater. They had no utilities. They had no water, no sewer, no trash pickup. They had no source of where their runoff would go. So they had no stormwater retention. And you say, well, there was nothing out there but vehicles. Well, that water's going to hit that vehicle and run somewhere. It causes erosion somewhere. Driving back and forth on grassed areas or unimproved areas, you deteriorate that grass that's holding that dirt, and the next thing you know, your property is eroding.
Okay, thank you.
Mr. Cox, you're next.
Yes, Teresa, page 11, utilities, 1B, the use of electrical cords is prohibited. Can you explain that a little more?
Yes, sir. We have had in the past found vehicles, same type thing as you find on people's recreational vehicles also. I think this thing, is it still on? Okay. What happens is they plug in an electrical cord, the big heavy ones, and they stretch it across. It may be a vacant area, it may be a parking area, in order to hook their tent or their temporary structure so that they have electricity. So we're going to prohibit those electrical cords from being used. Extension cords.
Okay, but wouldn't that preclude a lot of the temporary vendor thing? Because there are raised thresholds available to protect power cords that are laid temporarily.
You're
I don't-
talking about
I-
in event situations?
Yeah.
Yeah, no, this is not geared toward the event situations. These are people that are going to park out in front of a business and run that business day to day. And it is just not proven safe to do that on an extension cord. Think about, you've got a business, and we used to have another business sitting in front of it, and they were connected to the main business via a heavy-duty extension cord spaced across the landscaping, the parking area, and into the main business in order to supply electricity to that mobile vendor. That's not really a safe situation when a mobile vendor has the ability to having its own self-electricity. They have generators and things in it.
So they'll need to use a generator.
Yeah, they need a generator. They need to use their vehicle to
Got it.
provide the.
Okay.
Now, if there is already an existing temporary pole where they're at, they will be allowed to connect with that, but I think Gulf Power has to approve
Got
that
it.
connection.
Mr. Whitten, I have a
Yes, ma'am.
quick question. Up on the mobile vendors, it says that you can have up to 3 on a lot, and they have to be within 10 feet of each other. On site requirements, 1
No,
and
they can
2.
only they must be 10 feet across.
Right, but down here it says mobile food carts have to be at least 100 feet from another cart, including another food vendor. So that's kind of so if you have on,
This, if you're dividing them onto a site, such as you have a site, such as the corners over here where we have a mobile vendor site, it will allow those mobile vendors to operate on that site as a site.
okay,
So, like our mobile vendor site over here, it's not going to prohibit that from occurring. It's just people that are in your food carts, which are mobilized, which are driving. Keep in mind, your food cart is that. It is a cart. It's traveling down the road.
Okay.
It's not going to, a whole bunch of them's not going to line up on Main Street unless they're in an event.
okay. And because there's up here it had 10 feet, and down here it had 100 feet. That's what it was
Yeah.
confusing.
Well, that's your vendor operation there is under a different administrative code rule than your free-flowing carts are.
Okay.
Teresa, on page 10, it says temporary sanitary facilities shall be kept in clean and working order. Does that mean they have to have them, or if they have them, they have to be kept clean?
I think
On
we
page
have.
10.
Yeah,
Yeah.
and I think in another place, we actually require the waste. We actually require them to be there, so they need to be kept clean.
Well, the question I have, again, when we went through this over a year ago, I went and interviewed a lot of the mobile people around the city, and you take the Phil Lamb place down there by the old car lot. They have permission of the owner of that building to use their restroom facilities. So there's no reason for them to have portable toilets. Why would we require them to have them there if they have access to bathrooms?
Okay, if you look on page 8, when they're under item D, it's the location of temporary sanitary facilities and waste disposal. Most people don't understand that that's, a portalet. It's also, if you have an agreement to have temporary sanitary facilities, like in the primary building that's sponsoring you, that would be your temporary
That's what I'm
sanitary.
saying, But you just said they would be required to have the portalets, and I'm saying, not if they had the agreement.
Well, that's where they would clarify it in the site plan. So most of them are not operating on a place where they have facilities.
But if they do, we're not gonna require
Well,
them to have.
but see,
portalets.
on the site plan, they're going to determine where those facilities are at.
Okay. All right. Anything else?
Mr. President, I'd
Yeah.
like to make a recommendation that Teresa include in one statement in a section there, you stated that they shall not operate on public right-of-way. I think you should include public property along with that, because I'll give you an example. Last week I got a complaint. I had someone washing and waxing a car for profit over at the park. And when I addressed the issue and told them that was prohibited, and they said, well, why can so-and-so go over there and wash and do cars in City Hall parking lot? And he pulls his red truck over there in his trailer and he washes, and they pay him to do it. I said, yep, you're right. I said, let me research that. And our ordinances only cover public parks. It don't say public properties, so we can't have it both ways, I don't think. That's the council's decision, but I would recommend that you say public properties if the attorney agrees.
If it's public property, you got right to handle it however you want to.
Yes.
That makes sense. Makes sense to you? Yeah.
But can we regulate this parking lot?
We can, because we have it under lease.
Okay.
We just can't build anything permanent on it.
Okay.
Now, if what are you talking about reference, like if the mayor has a guy come over and detail his car while he's at work, so you can't do that on the public property?
Right, you'd have to take it to a designated area like this guy has. He takes most people over there by the news bulletin, I think.
But I think where you're talking about, we don't own that entire parking lot, is that correct?
This out here,
Yeah, it's just
we have it under lease.
the entire lot.
Yes, sir.
Okay, I was thinking it was just a part where, up close to the building, but it's
No, we have the entire
CSX
lot.
leases it, okay,
Yes, sir.
I didn't know that.
We good to move on?
Are we going? Okay. 604 Administration. Applications will be made to the Growth Management Department on forms provided by the department for the compliance certification and the temporary vendor permit prior to any itinerant vendor operation set up within city limits. Upon approval of the compliance certification, application for the operation as an itinerant vendor within the city limits, the applicant may submit a temporary use permit application for the specific location and time frames for the operation. Growth Management Department shall review the application, the duration of the permit, specifying such conditions as to location, parking, traffic, access, and all other conditions of the activity that might be required for permit issuance. And that's the end of administration.
Any issues with that? Yes, go ahead.
Just I wanted to reiterate, hold harmless to the city so that,
To be part of the application.
so that a vendor or a customer couldn't sue the city as a third party.
We will incorporate that into the application itself.
Okay, 102605.
Okay. Denial or, I'm not going to attempt that. Revocation. Yes. Y'all know I make up my own words anyway. So, of itinerant vendor compliance certification and/or temporary vending permit. Growth Management Department may revoke, suspend, or deny the issuance of any itinerant vending compliance certificate and temporary vending permit if it is determined that the applicant has been convicted of or have entered into a plea of guilty or no comment to the crime against the laws of this state, other state, or any other state of the United States, involved moral turpitude, fraudulent and dishonest dealings, and the illegal use or sale of a controlled substance. Number 2, has obtained a permit by fraud, false statement, misrepresentation, or failure to a truthful answer any question in the required permit application. Number 3, has failed to obtain required approvals from the state or obtain applicable permits or license. Number 4, upon finding imminent and hazardous threats to the public health or safety caused by the use, the Growth Management Department will take reasonable steps to prevent public access thereto and to eliminate such hazards, and may revoke and suspend the certificate for permit. Number 5, not later than 10 days after filing with the completed application for the vendor certification, the applicant shall be notified by the Growth Management Department of the decision of the issuance or denial of the license. If the issuance of the license is approved, Growth Management Department shall issue a temporary use permit upon review of the application and for said permit. Number 6, if the temporary use permit is denied, the applicant shall be provided with a statement of the reasons therefor, which reasons shall be entered in writing on the application.
Comments? I want to go back to the one I brought up before, because this is in black and white here. And again, I'm not standing up for one individual. The individual that brought it to my attention, in fact, no longer operates in the city. But how far are we going to go back? You know, it's this guy says, 20, 25 years ago, I got busted for smoking pot, and now you tell me I can't operate a business, which we have people doing that all the time, operating businesses that have minor crime. It is a controlled substance still, but it's very prevalent in our society nowadays.
I think the review, we're not trying to chase people down. What we're trying to do is make sure that the person is a business person in good standing, that they're honest and they're not out to misrepresent what they're doing to the public. So, as far as how far back, I would think if you're reputable the last 3 to 5 years, you're probably a pretty reputable person.
If
Or
you murdered someone 20 years ago, I'd hold that against you.
well, I'm sure if he had done that, and it would not be something that showed up in their background check other than being in prison somewhere.
Most applications ask if you have been convicted of a felony within the last 5 years.
That's primarily what it is. 5 years is about it. And that's what
That's
all
not gonna hang
companies,
somebody because they messed up when they were a teenager or whatever.
no, most all places where you do business, and, we're in business, we go through the background checks all the time. They're just criminal or felony, and it goes for a span of 5 years. And that's all it is. And it's done within a day or so, and that's it.
We're going to review all these documents. This
Right.
is the ordinance, and then you're gonna bring everything that supports this to us.
That supports this,
And we'll
uh-huh.
get to look at it again, right?
Right. Matter of fact, you're going to look at this 2 more times anyway. So-
Thank you. Thank you so much.
But yeah, we didn't, before we jumped out and did the supporting documents, and of course, if you noticed, your administrative code had the date of September 2018. Now you can have new documents. So,
Okay, I think we're ready to move on.
Move on.
To 606.
606, okay, no temporary vending permit shall be issued to any vendor to operate in residential zoning districts, because we're only going to be in commercial. No vendor shall enter into a house, building, or other structure or upon land, parcel, lot, or property without prior consent of the owner or occupant thereof, where there is placed or posted on the premises in a conspicuous position at or near the usual means of ingress egress for such location. A sign in a form of notice stating or indicating that the owner or occupant hereby forbids or likewise do not desire persons to engage in such similar activities or to enter the premises. No vendor shall conduct themselves or their business in an unlawful manner or in a manner as to constitute a breach of peace, is offensive to the public decency, or can be considered a menace to the health, safety, or general welfare of the public. It shall be unlawful for any person to sell or attempt to sell anyone a commodity by means of the vending such commodity upon the street, sidewalk, public area, public right-of-way, or private property in the city without first obtaining a compliance certificates with the city and securing the required temporary vending permit. So, I don't know if we want to go so far as to talk about citations. But I'm just going to let y'all think about that, and we'll go on to our exceptions if there's no questions.
I'm not sure I quite understand that, that D. I thought we said that we weren't going to allow selling or attempting to sell on public property. It says you can't do it here unless you get a certificate of compliance, which means you could do it.
Well, the thing about it, you've got your street, by coming and getting a compliance certificate, they will know all these things are denied. So that's the reason we included it in there. It's just that if you're looking at it, you can technically think about, are they going to sell Girl Scout cookies?
But what this implies is that you could do it if you get a certificate. Instead of just saying it's unlawful to do this. It's unlawful to do this unless you come get a certificate, which would mean the opposite is true. That you can't do it with a certificate. You can't do it without a certificate. Am I reading that wrong?
the rub.
This is not the first time we kicked this whole paragraph around, so let's reword that and
I would just stop, right
stop it after.
We're city.
City.
Instead of the comma, put a period. Without, you can't obtain it because you can't do it.
Well,
You can take out the private property part, because they
No,
can't
this
do it
says,
for private property.
yeah, I'm talking about the public.
Public part, yeah.
Public part. You can't. You're not supposed to be doing it in the streets. Although there are certain times that the public area allows it through events.
well, the key to that whole paragraph is down there where it says without first obtaining.
Right.
Yeah,
So-
without first
so
obtaining.
without first obtaining, it shall be unlawful. Now, if it's unlawful or prohibited,
They
and
can't.
somebody does it without first obtaining a compliance certificate, then they're in violation. Now, if you've got a guard dog on the front porch that doesn't bite, not gonna do you a whole lot of good. So this has to have some bite. You gotta come up with a way to issue a citation, and number one, is that going to be from the authority of the mayor or the police department? And how much is it going to be? And whether or not you give them an opportunity to go argue their case in court.
That's the reason I mentioned citation, kind of, I didn't include it in here. I simply mentioned it to you as to if this is some avenue that we still want to go down prior to sealing up the ordinance.
Well,
Yeah.
like I used to tell people that drove around with an expired tag. I would write them a citation, and sometimes they'll say, well, good, I'm glad I got that off my mind. I said, wait a minute, this isn't a free pass to drive around with an expired tag. You're still gonna have to go get a tag. So they're still gonna, if they wanna sell, they're still gonna have to go first obtain a compliance certificate, or they won't be allowed to do it. Now, you could just, I would have checked with legal, but I think you could just issue a fine. Is that right, Counselor?
I'm not sure what you're talking about.
Well, in order to expedite this,
They can't do it without properly applying for it. How they gonna be doing it?
well, even if they apply for it, they can't have it because some of those avenues are controversial. So unless there's some of the areas unless there's some of the areas that y'all wanted to permit. So it's obviously that y'all not are gonna permit you're not gonna permit the parkways, you're not gonna permit the park areas or public areas. Since we've made a great headway through down to here because we've already denied out the public areas, the parkway, the roadway, private property would be the only one that we really haven't touched. So we've killed out
That's what I'm saying.
three of these.
Either don't need it or reward it.
Yeah.
Take out private property. Because, and end it right there, you can't do it. It'll be unlawful. But what Councilman Fairclough was saying, at some point, we've got to include some kind of repercussions. If you tell someone they can't do it, but you don't have any way to fine them or give them a citation, doesn't mean anything.
Well, you could just group all that and say within the city limits of Crestview.
We'll bring-
Because again, that piece of land down there where they have the car sales, that's private property. But we're still not gonna let them sit up there and do anything without a compliance.
Right, because we have,
So that's private property.
it's my understanding that a consensus is forming that it's not gonna be allowed on vacant land and it's not gonna be allowed on unimproved
Well,
land.
I don't see anything
So-
wrong with this paragraph. It's telling you what you can't do unless you have a compliance certificate.
Mr. Cox, I'm sorry, go ahead.
Yes, as related to door-to-door salesmen who will need to have a temporary vending permit, is that correct? Okay, so could we make it so that they have to display that permit on their person?
We were
Because
thinking about
they
a
will lie and
badge.
say, I'm not a salesman, I'm just taking a survey, when we know that's not true, so.
Yeah, we thought about maybe having something that they attach, either a badge that identifies the dates that they're supposed to be out there, or we
Yes.
just haven't gotten that far because we didn't know if it was gonna make it through.
Is that gonna apply to kids and Girl Scouts?
No, that's nonprofit according to the exemptions we get there
Nonprofit.
next. That's it.
Cause I mean, I can just see little kids selling their $10 cards.
That comes down over in the bottom of the next thing.
Okay.
Well, we will bring something back for you to analyze on that particular area.
I thought we were still on D. The way some laws in the Florida statutes work is they will go through the entire article or chapter. And they won't say anything about repercussions for doing something that's prohibited until the very last part of that article or that chapter, and it will say something to the effect that any violation of any part of this article, chapter, whatever, shall come with a civil penalty not to exceed $500 or 50 cents, whatever you want to make it.
Well, I can tell you what the penalty was back when 1994, when they first, the only one that ever come through, I think, with an ordinance was, penalty for violation and failure to comply with the provisions of the home solicitation ordinance shall be punishable by a fine not exceeding $500 or imprisonment for a term not exceeding 60 days or both. Each day of violation of any provision of the home solicitation ordinance shall constitute as a separate offense. So if you're out there for 10 days, you got a chunk of change coming, $5,000.
If a law enforcement officer goes out there and writes you a citation for each one of those days, you can't just write him one citation and stack up all the days.
They didn't even write citations.
Whatever.
I mean, they
It's a
didn't.
civil penalty.
The civil penalty is about what they did, but they said each day that you're not in compliance, it multiplies.
So-
But that's like I say, that's what they were serious about it in 1994. So,
Go ahead, Mr. Cox.
So I think should have a written penalty in there, but where would you insert that in the document?
we'd have to,
Violation punishable by,
I think between prohibitions and appeals.
yeah, you would
Somewhere
need,
between. You don't have the appeals until you get the penalty.
mhm. Okay,
So you're gonna make a proposed,
we'll make a
Penalty
proposed
section.
penalty. Mhm.
you're gonna look at rewarding D, because seriously, I still have an issue with that.
What?
But if we can word it so it sounds, to me, it sounds contradictory, but bring us another version and we'll look at it.
Okay, y'all ready for 607 exemptions?
Yep, I think we are.
Okay, the following activities are exempt from the provision of the article. Salesmen representing wholesale houses or distribution who sell to local retail merchants from catalogs or samples. Number 2, sales of goods, wares, merchandise at festivals, carnivals, celebration, and special events sponsored and or permitted by the appropriate governing body or authority. Number 3, sale of privately owned and used merchandise at garage sales and yard sales conducted on the privately owned or rented premises used as a residence by the seller of such goods. So it means we're not going to govern yard sales. Number 4, the sale of farm, aquaculture, grove, horticulture, floricultural, tropical horticulture, and tropical fish farm products and products manufactured therefrom, except intoxicating liquors, wines, and beer. Number 5, sales of goods, merchandise purchased with donated funds or donated by owners thereof. The proceeds whereby are to be applied to any charitable, not-for-profit, or philanthropic purpose. Minors conducting home solicitation sales under the supervision of an adult or solicitor, salespersons, or agents making calls or soliciting orders on behalf of a religious, charitable, scientific, educational, or veterans institute or other not-for-profit organization are exempt from this article. Number 7, any public or nonprofit school which operates a carnival, fair, or other celebration by whatever name known, which is in operation for 3 days or less, and which includes the sale and preparation of food and beverages, must notify the local county health department on the proposed event and is exempt from any temporary food service regulations with respect of the requirements for having hot and cold running water, floors to which are constituted on type wood, asphalt, or concrete, or other cleanable material, enclosed walls and ceilings with screening, and certain size counter service. The school may not use this notification process to circumvent the license procedures for the chapter. So.
Nothing?
Appeals. Appeals may be filed as provided elsewhere in the within the Land Development Code. A permit may be reinstated provided that the applicant has met all conditions and requirements. Ready? 609.
Mr.
Compliance.
Stevens still has an input on that.
I had a question for the exemptions on, what about catering? Does that fall in the exemptions?
Catering is a business. Is a regular licensed business.
So, for
It's
instance,
not a-
like Mike Carroll or Jeff Jones comes to the community center and they have their grill and they're still cooking, but they're catering.
But they have to do it as part of the business.
They do it as part of the
They do,
event.
yeah.
We regulate that under the event insurance. They have to have their insurance and permitting for the event that they're catering at.
And they have to be a licensed business.
Right.
Well, I understand what you're saying, but doesn't that, well, I guess I see what you're saying. They're a licensed business even though they're mobile vendoring.
Right. They have to have a hold harmless license, insurance, everything to be a caterer at any event. Yeah.
If
But
they,
that will come up, I think. I thought about that today when I was reading through this. And with them cooking outside like that and not having inspections, or us not requiring any type of inspections being provided, that someone will question that.
well, keep in mind that the state, it actually is the one that monitors your food establishments, your,
We follow
Your-
those steps with our
yeah, your
concessionaires. I'm
Your
aware of those.
DBPR has a rules on it in their administrative rules. You also have state statutes that govern mobile vendors, and they're under two separate, they're 501 and 469, and they have to have multiple state and agencies that approve them. So with all that said, there's not much we're going to approve as far as the health and sanitation. We do not want to get into that. Let
No.
the state will handle that.
Even the vendors who do like the fall festival, they have to have.
They have to have all
a
that
license
state
from the-
licenses.
From the Department of Health. before they can
And,
serve food.
yeah, their Department of Health, and they've got to have their state licenses from DBPR, and the Florida Administrative Code has a whole section of licenses in there that they monitor, and they go out and do the inspections on these mobile vendors. The city will not be inspecting their mobile apparatus. The state has many avenues of inspection there. Are we ready to run the last few? The compliance certificate or permit is non-transferable. That's sort of pretty self-explanatory there. And 610, they must display the certificate and the permit on the vehicle. 611, the prerequisite of issuance of municipal or county occupational license. A municipality or county may not issue an occupational license to any business coming under provisions of this chapter unless a license has been procured for such a business from the division.
Teresa, that needs to be business tax receipt. Occupational license is a dead term now.
For the municipality and the county?
It's no
Okay.
longer occupational, it's business.
So it is business tax? I wasn't sure if it was for that or not. I've got a question in my mind.
Yeah, the occupational license got replaced with business tax receipt.
Okay. And
Oh, okay.
your division is, if you have read your definitions for your food service, you know, your definitions are all part of the divisions that pertain in state agencies. So your penalties, any person or business violating any provision of this article or any rule, order, regulation made pursuant to this article will be subjected to a civil penalty in the amount not to exceed $500. Each day the violation exists shall be constituted as a separate violation. The penalty provided for hereunto is accumulative to other remedies and enforcement processes the city may have, including those available under Florida Statute Chapter 162, Section 1, and Section 1-1 of this code. B, for the purposes of this article, a separate offense may be deemed committed for each day a violation of this article exists, and such time commencing on the day the offender is notified at violation. C, the person or business shall be in violation of this article for catering event, temporary sales of food, or vending machine activity in accordance to Florida Statute 509 and also Rule 61C 1.1025A of the Florida Administrative Code. So long as such person or business is not required to procure a license from the Florida Department of Business and Professional Regulation and or the Department of Agriculture for service of food to the public as a mobile food dispensing vehicle. Our references go back to the Florida Statute 500, the food services, and your Florida Administrative Code is your 5K, your Chapter 61C, and your FDA code. And that concludes the new Article 24. And you have included Chapter 496. You have the updated Florida Administrative Code from the division there. I did not print 509 as it's a very long one, but it only has a few elements that are involved with anything that we're handling. But if you do want a copy of it, we will be glad to provide it. I do have the National League of Cities, Foods on Wheels, where they're guaranteeing, we're going to have probably $1 million worth of food sales from trucks this year.
Ms. Mary, you have something?
Who will enforce all these permits and permits of compliance for a lot of different things going on in the city? Does our code enforcement officer check on that, or are you expecting the police department to take over another duty?
No, sir. Permits are issued out by the Building and Permitting Department.
Right.
And if you violate codes relative to the city code and the building code, the code enforcement officer will be the first area there.
Will that be going through the city and just seeing things set up, going there checking to see if the certificate of compliance is available to them, or will we wait to begin how are we going to decide who has a certificate of not? I mean, I know they get the certificate here, but if the code enforcement officer, whoever's doing this, is out and noticing some type of vendor that is set up and does not have, or is not aware whether or not they have a certificate, they will go into that.
They will approach and talk with them.
Okay,
Mm-hmm.
all right.
Just like we do with any other violations. Our ladies are very diplomatic, and our gentlemen are too. They're very diplomatic. They approach. Their main goal is to educate the public. And that's the reason we have just a fabulous rate of solving all the problems that we do come into. They got about a 99% solve rate. What they do is, first off, they will educate them. Will be equipped with the same documentation as when they arrive they proceed as a violation. They arrive there with educational material in their hand. They pull it from their truck. They attempt to talk with the property owner, and in this would be the owner of whatever food, is a food dispensing, if it's somebody that's set up a table and selling lemonade unlawful. But they will bring the education to them. They bring those educational materials. They will go over it. They will explain how for them to get into compliance. And then, therefore, when they arrive at our office, they walk them through the paperwork. They walk them through the process. And then they go on to have a successful time.
Okay, thank you.
Mm-hmm.
Teresa, is this going to be retroactive? That is, we're going to go and visit the guy selling Greek jewels that's been there for 13 years and say, now you have to undergo a background check and apply for this. Are we going to do that? All the ones that currently exist? Or are we picking up at the effective date? How are we doing that?
It's as it is with most laws. They do not become really retroactive when you're talking about land.
That's ex post facto. You can't
Yeah.
take today's criteria and apply it to something in the past.
No.
We'll make sure.
We just need to have some rules and regulations where we can proceed. We're growing way too fast, and we're really there's a lot more people now. If you think of what we've way more than doubled in the past 10 years. What are we going to be like 10 years from now? It's just to get time to get some control over it, sort of lay some ground rules.
Mr. Chairman, or President,
Yeah.
instead of making it retroactive, why can't we just allow them to operate on their current permit, and then when they have to renew, then it goes
They don't
into...
have permits right now. So basically, we're not going to go back. We're not going to mess with them.
So,
They do have a type of BTR.
But not
Mobile
what
food
we're
vendors
requiring.
do.
here.
Mobile food vendors have a type of BTRs.
yeah,
But they're more a permanent location, not somebody's just gonna be there for 10 days or whatever.
Right. But there's still, when we get, as a matter of fact, this afternoon, we're doing Matthew's Barbecue, who will be moving off out of the county from Industrial Drive over to an area over by Woodlawn Church. So, yes, it hits our desk as a BTR. So, and he has a mobile truck. I'm sure you've seen his barbecue truck. If you've driven down Industrial, you have smelled his barbecue truck. And if you can possibly find a way into that little crowded lot where he's at, you've probably tasted his barbecue. So he will now be becoming a businessman inside the city. So.
Any other comments, questions? Anything else you need to address to us on this?
No, sir. I just,
All right, we have any other items? Ms. Mayor, you have anything for us?
No, sir.
You have, Ms. Fairclough?
don't think so.
Ms. Cox? Mr. Holly? Madam Clerk, have anything for us?
Just two things. I'll remind, the regular council meeting is November 5th, not November 12th. And if you're gonna have a veteran in your cart, I need their name that night, if not before.
Mr. Steele, you have anything for us?
I just want to request a meeting with you when you have a chance with Chuck and I to get a better understanding what you want set up at Warriors Hall.
Okay,
If
all right,
you've got a minute to meet with Chuck and I sometime this week.
we can do that.
Okay.
Put that on there. Anything for us?
Nothing.
Okay. You got anything else for us?
well, we jumped into the meeting for November 5th, which y'all have a good time. I'm on vacation. But we didn't say about our meeting next Monday. The 22nd.
Warriors on?
Well, I'm gonna get to that in a minute.
You're gonna get to that?
Yeah.
Okay, good deal. I just didn't want y'all to forget it.
We're not gonna forget it. We got a lot of writing on that. Did you get any other, inputs on that sheet we had on the last meeting? If not, I need to see what that was, what we committed to on that. You know what I'm talking about? We signed up to introduce groups.
We had groups and all. It's in my office.
Just-
But we didn't get really any.
No, I just wanna
Any
make
mo-
sure that I have the right ones down there. who's gonna
Okay.
do what. But yeah, that's going along well. I mean, on the 22nd, it's gonna be a big open house, and I'm gonna get with Wayne, we're talking about the tables we're gonna set up. And we're gonna add a table, so I'm glad you brought that up, because today, the city clerk and I attended a meeting over in Fort Walton Beach to deal with a half-cent sales tax increase and trying to get the word out, especially in the north part of the county. But let me tell you this, that not only did all the other cities tell the county commissioners that the number one project in Okaloosa County is fixing State Road 85 in Crestview. This meeting today, they all came up separately to me or Madam Clerk one time, and I said the same thing. They're hanging in there. They're not backing off and saying, no, we'd really like to do this for our city. They want things for their city, but they all acknowledge their people are traveling back and forth to Crestview, and it's driving them crazy, and so they're supporting us and making that the highest priority in Okaloosa County. Just convince the county commissioners and the citizens group to make it number one priority, and they gave us some things to hand out. There were some right there that I was going to give to Councilman Hayes to give at his town hall meeting, and there'll be something coming out. Kenny's going to be doing an interview with me on Wednesday, promoting the increase, and I'll be trying to get something in the newspaper, because on Facebook I have heard people say that we don't have enough details about this yet. They want to feel good about it, so we need to go out and we can, as elected officials, we can go out and we can promote it. What we can't do is use taxpayers' money to influence the outcome of the referendum. We can't do that. We can all go out and give our personal opinions.
Yeah, it's the same thing applied to the charter.
That's, same kind of rules. That's all I have.
Mr. President,
Yes, go ahead, Mr. Mayor.
one more thing is that Nathan Sparks called me last Friday, and Triumph Gulf Coast was looking for another place to hold their meeting. Their next meeting was scheduled for Port St. Joe. Of course, they can't hold it there. So I offered them Boyers Hall, and Betsy and I talked to them about that. What is that date, Betsy? I don't have it in front of
The
me.
23rd? Or is it the Tuesday after our meeting, or?
I think it was a Tuesday, but I don't want to
What's
say
that
it.
now, the EDC?
The
Triumph.
Triumph
Oh,
Gulf
Triumph.
Coast.
Oh, yeah, bring them here.
Date.
I was real anxious for them to come.
Whatever day they want.
Whoever they
Yeah,
want, basically.
whatever day, whatever time.
We may have steaks for them or something. Refreshments.
For some reason, it's not on my calendar. I'm gonna have to look at, but I know we put it down, but I don't remember what.
We'll get that out to
I'll
you.
send it out to you tomorrow.
Okay.
And just about to forget that, so.
All right, do we have any inputs from the public?
And you don't have anything?
Public of one.
Come on, Nathan, come on, Ian, say something.
Seeing none, this meeting is adjourned. Thank you all for coming.